we go. Hello.
Okay, so we're ready to start again. Here with us now is Pamela Morgan, who is an attorney, entrepreneur, and educator, and who's working to promote cryptocurrency use and acceptance in the legal space. She is also the CEO of the company Third Key Solutions, so we are very excited for her talk. Take it away.
Thank you so much. Oh, hi. Oh, no, you're not still sleeping, are you? I'm an American. We got to liven this up. Also, I've had 3 coffees. Did you know they have free coffee? No. So, good morning. I am so happy to be here. I love this topic. I love talking at Bitcoin and blockchain conferences, and I love combining both Bitcoin, blockchain, and the law. I think it's one of the most interesting combinations that is underrated today. So, as Hannah mentioned, I'm the CEO of Third Key Solutions. That's a key consulting and management company. I also have a law firm called Empowered Law, and I'm also a board member at the Crypto Consortium, which is a nonprofit standards organization. They specialize in doing particularly the CCSS, which is the cryptocurrency security standard. It's for enterprise businesses to make sure that they are storing and holding keys securely. But that's not what this talk is about. This talk is about, it's about how to protect yourself like a multinational on a startup budget. And this QR code is not a donation address, for those of you who are Bitcoiners. It is a link to an article that I've written on this topic. So you don't have to take notes, you don't have to try and furiously remember the things that I'm telling you. An article is available, and I'm also happy to share these slides with you. If you send me a message, I'm happy to send them to you. So let's get started. Our industry is facing a pandemic, and the problem is we have extreme exposure to jurisdictions all around the world. How many of you are entrepreneurs in this space? Bitcoin, blockchain. So, oh, you're shy. You're like, kind of me? Okay, let's get a quick poll of who is here. How many of you own Bitcoin? Okay, so maybe half, maybe a little more than half. How many of you own Ether? Roughly the same amount. You're owning both. Well done. And how many of you work full-time in Bitcoin or the blockchain space? Okay, maybe 4, 5. And how many wish you did? Excellent. Okay, so way more. I am here to tell you it is doable. I learned about Bitcoin in 2013, in late 2013, at a conference. I was speaking at a conference about entrepreneurship for people with disabilities. And one of the other speakers here, who you happen to hear today as your keynote, Andreas Antonopoulos, was there speaking about Bitcoin. And I was in the audience just like you were this morning. And I was like, holy wow, this is going to change the world. And I want to be part of it. So for the next 2 months, I continued to work my other job, and I nerded out about Bitcoin. And 2 months later, I quit my full-time job, and I decided I was going to make a career for myself in this industry. So I've been working in Bitcoin and blockchain ever since, so it's about 3 years now. So for those of you who really are interested in working in this space, it is absolutely possible to do. And there are many of us who have very similar stories. This is an area for startups, and that's one of the reasons why I'm here talking to you today about what I'm talking to you about. Because these technologies are truly global in nature. They really are borderless. And one of the problems with being borderless is our jurisdiction, our local laws are not borderless. And so if you're a startup and you're working in this space today, unless you carefully cultivate your client list and eliminate anyone who's outside of your local jurisdiction, you're going to be exposed to laws and jurisdictions all around the world. And for me, that represents an unacceptable business risk. But there's a vaccine. Good news, right? The vaccine is the freedom to opt out of traditional court systems. And that vaccine is arbitration. How many of you have heard of arbitration? Great, the majority of you. And how many of you are parties to an arbitration agreement? Okay, how many of you have a bank credit card? Oh, all of you. Great. All of you are parties to an arbitration agreement. You just didn't know it. All multinationals, large multinationals, including banks, use arbitration clauses in their terms and conditions. You read those, right? Yeah, no, okay, me neither. But if you do, you will see that they all include an arbitration clause. And the reason that they include an arbitration clause is because of this jurisdictional problem. Because it's very difficult to assess the business risk when you don't know what the rules are that apply. With arbitration, we get to make choices on what rules apply, who the judges are. We get many more choices than what we would get in a traditional court system. This is a map of what's colloquially, I'm not even pronouncing that word right. You know what I mean. What's termed the New York Convention. And it's a series of treaties. And as of 2001, the countries in blue, which you'll notice Norway is one, are parties to this international convention. Why this matters is because this international treaty has all of these countries agreeing to enforce arbitration awards of the other countries who are part of the treaty. Meaning that you'll see the United States is there, I'm from Chicago. So let's say that you and I have a disagreement, okay? Let's say that you and I buy services from your company and we have a disagreement. Where do I file the lawsuit? I'm not coming to Norway. Okay, I'm going to file the lawsuit in my local jurisdiction, right? So if I do that, and I file the lawsuit in my local jurisdiction, and I say, hey, will you please come and defend yourself against this lawsuit? You may or may not show up, and I may or may not get a judgment against you. And then comes the second problem. How do we enforce it? You have a judgment in Chicago, right? I get a judgment in Chicago, and what do? I come to the Norway judge and I say, Your Honor, would you please enforce this agreement? And what does the judge say? Maybe, if they feel like it, right? They don't have to. Does a sovereign have to recognize the award of another sovereign? Absolutely not. Let's contrast that with arbitration. Let's say you and I have an agreement, something goes awry, we have an arbitration clause. We have an arbitration award. Doesn't matter if the hearing is in Chicago, doesn't matter if the hearing is in Norway. The hearing could be totally online if we wanted it to be. Let's say you get an award. Let's say I get an award. Now I come to the judge in Norway and I say, Your Honor, I have this arbitration award, and pursuant to the New York Convention, I'm going to need you to go ahead and enforce that, please. And the judge has no discretion. And the reason the judge doesn't have discretion is because Norway is part of this international treaty. This works both ways. So you could bring an arbitration award that happened here in Norway and serve it and enforce it on me in Chicago. So this is a really, really powerful tool. And this is why the banks use it and the multinational companies use it, because it's kind of a get out of local jurisdiction free card. Enforcement is what really matters. It's what really matters even if you have paper contracts, right? We have promises. Contracts are just promises between people. They're just paper promises. With smart contracts, some of those promises are enforced by code. But ultimately, they're just promises that people make to one another. The real question is, when those promises are broken or when expectations aren't met, how do we become whole? How do we get enforcement of our rights? With arbitration, we have the freedom to choose. We have the freedom to choose many, many, many things, and we're going to go through this step by step. First of all, we have the freedom to choose substantive law. How many of you know what the term substantive law means? Okay, so we have two, and you're lawyers in the room, yeah? Okay, good. Substantive law simply means what jurisdiction's laws apply, okay? So what is a breach of contract? What is fraud? What are the elements of fraud? What elements would you have to prove to a court or a judge to say, yes, this person is guilty of fraud? And in each jurisdiction, those elements could change slightly. So by determining in contract what substantive law applies, you by default negate all of the other laws. We'll go back to our example of when I'm in Chicago and you're in Norway. Which law of breach of contract applies? I don't know. Neither do you. You have no idea. Why? Because we didn't say what substantive law applies. So it's very simple. All you say is the law of Oslo applies. Very simple. It doesn't have to be a bunch of legalese. It can be a very simple one word or a couple of words addition to your contract or to your terms and conditions. And you will then get the limitation of choosing substantive law. This matters when you're doing risk assessment. It also matters when you're looking to settle agreements, right? If you don't know what law applies, you don't know if you've broken the law. Therefore, you don't know if you should pay out on a settlement. In addition to substantive laws, there's procedure. So there's substantive laws and there's procedural laws. Like, really? Yes. The procedural laws are things like, if I file a complaint against you, how long do you have to respond? In federal court in the United States, it's 21 days. So you have 21 days to respond. How would you know that? Well, they're in the procedural laws of the court. So it's more than just what is breach of contract. It's all of these procedures. How big does your brief have to be? What are the margins? All of these sorts of things. Those are all delineated in procedural law. And again, you can choose procedural law in your arbitration clause. You can simply say, the substantive and procedural laws of Norway apply. Simple. You can also choose venue. What I mean by that is you can say all of our hearings will happen in Oslo. All of our hearings will happen in Chicago. You can choose anywhere, really. This is a big one. With arbitration, you can choose your judges. So do you get to choose your judges here in Norway? Do you get to decide which judge is going to hear your case? I'm going to bet not. In the US, it's done by a lottery. So whatever judge is their turn, well, that's the judge you get. And they may not have any understanding of your business. They may not have any understanding of cryptocurrency. Likely they don't. So with arbitration, we can choose who our judges are. And interestingly, they don't have to be lawyers. So you could choose the subject matter expert. You could choose a lawyer. You could choose an accountant. You can choose anyone you want. And you can decide who those people are either by way of your arbitration agreement or later by deciding a process on who you will choose as your judges. You can also choose the number of judges. So by default, here in Norway, you have an Arbitration Act, which was passed in 2004. It says by default, you will have 3 arbitrators, but you can choose to have 1, you can choose to have 3, you can choose to have 5. I wouldn't pick an even number. If you pick an even number, you'll have a stalemate, and that's no good. So you want to pick an odd number, right? 1, 3, 5, etc. Remember, the more people you get, the longer the deliberation is going to be, right? The more people you get to be judges and decide, the more challenging it will be to have them reach agreement. But you get to choose that with arbitration. You can also choose stepped. So you can say, if our agreement is less than $100,000, we will have 1 arbitrator. But if it's more, we'll have 3. You can do that with arbitration. You get to choose the language. So you can choose whether it's Norwegian, English, whatever. You can also choose the duration, which I think, coming from the United States, is really appealing. You may or may not know that in order to get through all of the appeals in the US up to the Supreme Court, it typically takes between 7 and 10 years. That's not really great if you're trying to operate a business, right? That's a lot of money, that's a lot of time, and that's a lot of focus on things other than running your business. With arbitration, you can select the duration of the hearing. You can choose something as short as, from start to end, 6 months. And that still fulfills due process in most jurisdictions. So you can say, instead of having this thing go on years and years and years, we're only going to have it be 6 months. You can also decide how long it will be from the time the hearing ends until the time you get an award. In the US, sometimes it's years before the judge actually makes a ruling. Here you can decide it's going to be 1 month, 30 days, and they have to give you a ruling. You can decide, to a certain extent, what evidence you will allow. Some of you have heard, how many of you, do you watch Law and Order here? Do you know Law and Order? Oh, I see some smiles, okay. So, it's not really like that, you know that, right? It's a good show, but that's not really how it goes. You really don't usually get someone on the stand who's confessing. Evidence is a big deal because that's going to ultimately determine how your ruling happens. And so in the US, we like to do things called depositions. Anyone know what a deposition is? Oh, many of you. Very good. Do you have those here? You do them often? No. You're like, no, you're making faces. So a deposition is when a lawyer will bring you into a room and they will record asking you questions. Basically, it's the same thing as what you would do in court. It's just before and not in court. So most civil law countries view that as a huge waste of time. With arbitration, you can decide to have no depositions. You can decide to make a ruling on documents only, which saves a ton of time, a ton of money. You can also decide how much of your hearing is confidential. This is not a choice that you have in traditional court. You can decide how much of it is going to be private. You can keep it all private if you want, or you can make it public. You can also require a written decision. In the US, often trial courts do not give a written decision. They will make a ruling from the bench, or they will make a decision, they will make a written decision that doesn't actually have their reasoning behind it. A written decision is important if you want to try to appeal. Also, if you want to try to understand, what was the judge thinking? Why did I lose? If you have a written decision, you can figure that out, and then you can change your behavior next time, rather than just saying, oh, you lost, too bad, and you still have no idea why you lost. Also, we can control appeals. So with an arbitration clause, you can say, we are limiting this to one appeal. We are having no appeals. We are having an expedited appeals process. We're having a 12-stage appeals process if you're feeling litigious. It's up to you. You can do anything you want. So you get to choose all of these things. And that's why I think that this is so important. Again, going back to the enforcement, on top of all of that, arbitration is superior because of enforcement, because we can enforce this all around the world. Ultimately, it gives us the freedom to choose. Many in our industry are under the illusion that they are not subject to jurisdiction. I call that the placebo. They say, oh, no, you don't know who we are. You have no idea. We're not subject to jurisdiction. And while your organization may not be subject to jurisdiction, you as an individual are. And so if you're taking the benefit of a corporate act or of an organizational act, trust me, they will try to find you and you will be part of whatever jurisdiction you're living in. I wrote an article called ARIAL 11, Default Law. Do you know what the font is when you open up a Google Drive document? It's ARIAL 11. Why does that matter? Well, it only matters if you don't want ARIAL 11, right? Maybe you want Comic Sans. Maybe you want Times New Roman. This is the same with the law. There is always a default law that applies. So even though you don't know it, it still exists. Just like when you open up a Google Drive document and you start typing, you're typing with ARIAL 11. This is the same concept. There is always a default law. And you get to change it, but you have to take affirmative action to do that. You have to change it by way of contract. And you can do a lot of this through arbitration. So many people also say, you know what, I'm not going to do this. I'm only going to deal with people who have full anonymity, who are running on tour, who are doing all these things. And I say, okay, that's fine, but you've significantly limited your ability to transact if that's what you're doing. And I think it's much better to expand the scope. So what do you need to do to be strong with arbitration? One, it must be in writing. If you don't have it in writing, it doesn't count. So you need to add this to your terms and conditions, add this to your founders agreements. If you have a startup and you don't have a founder agreement with your partners, you need one, and you need one today. Contractor agreements, pretty much any contract that you have, you can add an arbitration clause and get all of these benefits. So you're not a lawyer. You don't know how to write an arbitration clause, and you're not really keen on hiring one right now, or you're not really sure. You can use this DIY clause builder, and it will help you construct an arbitration clause for free. So you can look at, what does this look like? What would my arbitration clause look like? And you can play with the parameters. And it's, again, a free tool. It's through the American Arbitration Association. However, it does have an option for international arbitration. Remember that nothing is 100%. Nothing can save you from your SEC enforcements, from your criminal enforcements. This is strictly for civil business-to-business sort of contracts. Interestingly, when we start adding arbitration, we can increase innovation in legal services. And I think this is one of the most important side effects. If we create a floor of arbitration, we can start doing things above it. How many of you have heard of mediation and arbitration? Usually they go hand in hand, right? So step 1 is mediation, step 2 is arbitration. But what if it wasn't mediation? What if instead you could do a mediation DAO? What if you could do a crowd jury? What if you could do something else? We can. And we can do it in a commercially viable way so long as we have a floor of arbitration, so that if those things don't work, we don't fall into local courts and have to replay all of the costs and effort. Remember, it's all about having the freedom to choose. The thing that I care about most in this space is uncoupling identity from justice. So right now, our justice systems require that we have identity in order to avail ourselves of enforcement. I don't think we have to do that. And I think with cryptocurrencies, where we have identity optional systems, we shouldn't force identity in order to have justice. We have a project called the DAM Project, which is the Decentralized Arbitration and Mediation Network, which is an ADR dispute resolution platform for Bitcoin. If you're interested, it's available on GitHub. I want to thank you very much for your time and attention.